Hello and good morning, and welcome to Gough Square Live. My name is Jonathan Goulding, and I am joined by Laura Phillips. Laura and I are both barristers at Gough Square Chambers practising in consumer and trading standards law. Today we're going to be talking about due diligence defences. The aim of our talk today, which will last about 20 minutes, is to give a high-level overview of the main principles of this statutory defence, which is available in relation to many strict liability criminal offences. We are sure that many of you will be familiar with this defence, having considered its merits, whilst investigating an offence on behalf of a prosecuting authority or when defending a client facing investigation or prosecution. We will be looking at the elements of the defence, the key principles, some of the authorities, and giving some examples of how the defence might be proved in practice. As in previous Gough Square Lives, we won't be answering any questions on air, and we will try to keep the whole talk, as I've said, under 20 minutes. Do still feel free to email us later if you have any questions. The statutory due diligence defence has been available to defendants defending strict liability offences for a very long time. It certainly predates the Trade Descriptions Act 1968, which provided for the defence in section 24. A good example of one of the many strict liability offences where the defence is available can be seen in Regulation 12 of the Food Safety and Hygiene England Regulations 2013, set out in slide 3. The rationale for the defence is to permit innocent defendants to avoid punishment for strict liability offences where criminal liability does not result from personal fault and is often the act of another person, and the defendant took all reasonable precautions and exercised all due diligence. Laura.
The wording of the due diligence defences in various legislation varies slightly, but generally they provide that the defendant has a defence if it can prove that it took all reasonable precautions or steps and exercised all due diligence to avoid the commission of the offence by it or by a person under its control. The burden of proof is on the defendant to establish the defence on the balance of probabilities, more likely than not. The defence only arises if the prosecution can prove beyond reasonable doubt that an offence has been committed in the first place. In many cases this will be straightforward and not seriously in dispute. To take an example under the hygiene regulations, if there's widespread evidence of a mouse infestation, it's going to be quite difficult for a food business operator to argue that it had adequate procedures in place to control pests. But even where the offence itself is disputed, it is very likely that if there's going to be a trial, whether or not the due diligence defence has been made out will be a key issue. The key point when it comes to this defence, as the House of Lords emphasised in Tesco and Natras, is that what amounts to a due diligence defence is a question of fact depending on the circumstances. It's up to the tribunal to decide on the facts whether or not the defendant has discharged the burden of proof. In order to do that, the tribunal will need to look at things like what systems the defendant had put in place to prevent the commission of an offence, and will also need to decide whether those systems demonstrate that the defendant had done enough to try to prevent the offence being committed. What is enough in the circumstances depends on the size and type of business and the resources available to the defendant. More is expected of a large national retailer than a small independent corner shop. So how does this work in practice? Unsurprisingly, the authorities are all highly fact-specific, but some general points emerge. John?
Yes, thank you, Laura. Whilst the defences are fact-specific, as you say, it is worthwhile looking at some cases from the higher courts that considered the proper exercise of the defence. It is not correct to say because the offence was committed, the defendant did not exercise due diligence, as the magistrate did in Bow Street Magistrates Court ex parte Cowan Gate. It is obvious that if an offence has been committed, something by definition will have gone wrong. The exercise for the court is to see whether reasonable precautions and due diligence existed to seek to avoid the commission of the offence. The court should formulate the test in accordance with the language in the legislation. Did the defendant take all reasonable precautions and exercise all due diligence to avoid the commission of the offence? In Croydon against Pincher Pound UK Limited, in the Administrative Court, the lower courts were reminded by that court that the defence is couched in ordinary language and the words are readily understood. Mr. Justice Roderick Evans considered that only rarely would it be necessary for a court to formulate the test in anything other than the language used in the statute. Many of the cases involve very large corporate organisations where the company cannot undertake the detailed supervision of all employees and has to delegate supervisory duties to more senior employees. There must be a system under the directing will of the defendant to avoid the commission of offences and a proper operation of that system. When a large company is involved, the system can be by means of delegation of responsibility to employees. The defence will avail itself if such a defendant has taken all reasonable precautions in the selection and training of servants to perform supervisory duties, has devised an effective system to avoid acts or defaults on the part of its servants that would lead to the commission of offences, and also used due diligence, i.e. to satisfy itself that such system was being observed. It is a question of fact and judgment for the tribunal. It does not destroy the due diligence defence for the prosecution to say something else could have been done that was not, as in the case of William Frank Smith against T&S Stores plc. All reasonable precautions does not mean all possible precautions, as was said in the Carrick District Council case against Taunton Vale meat traders. If despite doing everything it reasonably could, and the commission of an offence still occurs by the default of another, i.e. human error of a subordinate employee, an acquittal should follow. So what kind of things will the court look at? Laura?
Well, evidentially, the key question is, what system did the defendant have in place to prevent the commission of the offence? That's going to involve looking at three things: policies, implementation and monitoring. So let's start with policies. What was the system? What were the relevant policies and procedures? Were they proactive? Did they work to prevent the issue, as well as proactive, so working to respond to issues as they arose? To go back to our pest control example, examples of proactive policies would be routine pest control contracts, checking for signs of pests, having cleaning procedures. Reactive policies would be, for example, having a policy about what to do if there were any sign of pests, such as in this case, droppings. The court will then have to look at whether those policies and procedures were appropriate for this defendant. And a key question for the court will be resources. So looking at our food safety example again, it might be sufficient for an independent cafe to use the Food Standards Agency's Safer Food Better Business Pack as its food safety policy, but a national supermarket would be expected to have policies tailored to its specific business. The second thing the court is going to have to look at is, how was the defendant's system implemented? That means, how is it communicated to employees? And that will involve looking at things like employee inductions, employee training, news bulletins, and things like that.
Yes.
It will also involve looking at things like record keeping. So to keep with our pest control example, it will involve looking at any records that were kept of routine pest control visits, any records that were kept of daily checks and cleaning. The court will then also have to look, and this is the third thing, about we'll have to look at how implementation of the policy was monitored by the defendant to see whether local failures or single instances of failures are being picked up and remedied. So it will look at who was checking that the policies were being followed. So to take our pest control example again, who was looking at the defendant's paperwork to see that it was being completed? Prosecutors, when bringing proceedings, will need to consider, as part of the evidential sufficiency test, whether a due diligence defence is likely to be made out. That should be part of their investigation. And so there will usually be some evidence within the prosecution's case as to the defendant's systems, and that is effectively advance rebuttal evidence to show that the defendant has not made out the defence. And it should be noted that there is a fine line between a successful due diligence defence and what amounts to good mitigation. Where precisely that line lies is up to the court. So defendants need, facing these types of offences with due diligence where a due diligence defence is available, will need to carry out a risk-benefit analysis in order to decide how to plead. They will have to balance loss of credit for an early guilty plea against the possibility of an acquittal. And that isn't always an easy decision, particularly now where the courts can often impose very high fines for offences. Finally, on this point, it's important to be aware of any notification requirements in relation to due diligence defences. For example, to go back to our food safety example, Regulation 12.5 of the Food Hygiene Regulations says, if in any case the due diligence defence involves the allegation that the commission of the offence was due to the act or default of another person, or to reliance on information supplied by another person, the accused shall not, without leave of the court, be entitled to rely on the defence unless they have given advance notification at least 7 clear days before the hearing, or where the accused has previously appeared before the court in connection with the alleged offence within 1 month of the first appearance. And that notification has to be in writing, and it needs to identify who it is said to be at fault. And the purpose of that is to allow the prosecution to investigate, and also to investigate what's being said, and also to consider whether that other person ought to be prosecuted instead or as well as the defendant. Failure to comply with that requirement could, in theory, lead to the court refusing to permit the defendant to put forward a due diligence defence at all. More likely, what would happen is the court would adjourn the case, and potentially there'd be an application for wasted costs against the defendant.
Yes, thank you, Laura. So the key points to take away from this are this. Each case will be highly fact-specific. There is no magic to it. The words have ordinary meaning. It is a question of fact for the court to decide whether the defendant has made out the defence. Namely, whether it is more likely than not that the defendant took all reasonable precautions and exercised all due diligence to avoid the commission of the offence. Thank you very much for listening in today. Hopefully we have provided you with a useful overview of the due diligence defence. Please feel free to get in touch with us by email with any queries, and we will try our best to provide you with an answer. And finally, please tune in to our next instalment of Gough Square Live, which will be on February the 6th, when George Spence-Jones will be speaking about the consent, connive and neglect provisions found in consumer legislation. Goodbye from us.
Goodbye.